You may be seated. Last case on the docket is Brown versus BRIGANCE. West?
May it please the court, my name is Richard West. I'm here today representing the appellant Bruce Brown on an appeal from a final judgment of dissolution of marriage. We're here on a very narrow issue on a de novo review of the construction of a prenuptial agreement. The parties entered into this prenuptial agreement, and the provisions that are at issue have to do with the enhancement in value of the wife's dental practice. Dr. BRIGANCE was a practicing dentist at the time of the marriage, at the time the parties entered into the marital settlement agreement, and the two operative provisions of the prenuptial agreement contained a waiver in paragraph 2 of the enhancement in value of the practice. The agreement was entered into approximately 2 years after the opinion in Doig versus Doig, yet did not contain what we refer to as Doig language, i.e. there was not a specific waiver of both passive and active appreciation. Passive appreciation being that which occurs because of market forces and through neither the efforts or funds of either of the marital partners, active being contribution of marital funds or marital labors. And the parties agreed, and Judge Reinman, who entered a partial motion for summary judgment, found that it did not contain the Doig language, and therefore the active increase could be considered, except for paragraph 4.
Would you agree that the Doig language is basically equivalent to paragraph 2, and that in the Doig case they weren't dealing with an equivalent of paragraph 4?
I'm sorry, Judge.
In other words, if you just had paragraph 2 in this case, you didn't have paragraph 4,
it would be
that
Doig.
would be equivalent to Doig.
Yes.
But Doig didn't have the equivalent of a paragraph 4.
I don't know whether it did or not. I've never read the Doig agreement. It was certainly not argued or not part of the opinion in Doig, but we just don't know.
Okay, because in the Worley case, which is out of the same court, but 2 years later, I think Doig was second DCA, right?
I think so, Judge.
Yeah, Doig was 2001 second DCA, and 2 years later they had the Worley case, and they had a provision similar to Doig. But then there's a current opinion by Judge Altenburn where he says, that if the prenuptial agreement regarding property had contained the phrase, quote, even if acquired with marital income or by virtue of marital labor, unquote, I expect that we would reach a different result on the issue of equitable distribution. So, in that case, the second seems to be suggesting that if there's a provision about you get to keep your marital income, or if you purchase property by marital labor, and you have that in the prenuptial agreement, then apparently no equitable distribution. I mean, is that what we have here? I
don't think so, Judge. Virtually every active family lawyer probably collectively gasped when they read Doig, thinking, "Oh my, what have I got out there waiting for me?" And we did seminars, we attended seminars. There's articles written, and everybody immediately rewrote their agreements, their prenuptial agreements, to contain this Doig language to protect against that situation. And as we cite in our brief on, I believe page 13 of our brief, footnote 5, we cite the Johnson opinion where we say the trial court remarked that it could not assume that husband's counsel was unaware of the equitable distribution development in Florida law, particularly since it occurred 2 years before this agreement was executed. And I think that's the same thing here. This court and the trial court should not assume that the attorney who drafted this agreement was unaware of Doig and possibly Worley as well, although I'm not certain of the date on Worley. I think attorneys are presumed to have knowledge of the current status of the law, and if there had been a clear intention to waive any marital interest in the active appreciation, then it would have been clearly stated.
Let me ask you this. If the value of the dental practice had gone down, would your client have to share in the loss?
Not according to Anson. I don't think. Whether that's fair or equitable or not, I don't know. But the statute only talks in terms of enhancement in value. It does not talk to us about diminution in value. So I don't know how to answer that question truly. I mean, if in an equitable circumstance, it would seem to be that if you're going to, you take the goods, you got to take the bad with it. But the statute doesn't say that, and Anson doesn't seem to say that.
Does everybody agree this agreement is unambiguous?
I believe it's unambiguous. I don't know what it seems that if you read both briefs, everybody's saying it's unambiguous and the court cannot rewrite the contract if the language is unambiguous. So I think the question comes down to the particular language found in paragraph 4.
I think the question is, what's an accumulation?
Exactly.
It's not defined in the agreement, right?
It is not defined in the agreement. I would submit to this court that if you read paragraph 4, earnings and accumulation and earnings and income are treated interchangeably. If you read paragraph 4, I've marked it here, it says all earnings and accumulations resulting from each party's personal services, skills, efforts, and work, together with all income derived therefrom, shall be the separate property of the party to whom the earnings and income are attributable. They don't say the earnings and accumulations attributable. And then they go on and they say each party understands that except for this agreement, the earnings and accumulations from the personal services, etc., would be marital property, and that by this agreement, the earnings and income. So they use those terms interchangeably within that paragraph. From that standpoint, I think that the prenuptial agreement was fairly clear that paragraph 2 dealt with assets and paragraph 4 dealt with income. And again, this paragraph 4, I think, was a result of that case I cited earlier, the Johnson case and the Witowski case, that were coming out at about that time that said, look, unless you make a clear waiver of income earned during the marriage is a marital asset. So there was an attempt to waive, and I think, valid, they did. They waived Mr. Brown's interest in her income. But there's nothing here, there's absolutely nothing in this agreement that waives the appreciation in the value of the practice by either party. It should not.
As I understand it, what the trial court ultimately said was you could prove up what you, husband, contributed towards the value. You're not entitled to what the wife's efforts contributed to the value.
That's correct.
Did you present testimony as to each of those elements? Each of those did your testimony divide it between those two? Here's how much it was enhanced by what the husband did. Here's how much it was enhanced by what the wife did.
Judge, I was not trial counsel, but here's what I can tell you: the portions of the brief that talk about that said that there was expert testimony presented that the total enhancement in value was $219,112, of which 50% was passive and the other 50% was active. I'm not sure, because the summary judgment that Judge Reinman granted limited the presentation to what the husband's contribution towards that was, and the figure was approximately $27,000. I think that our position in this is that it was improperly limiting, that he should have been allowed to argue for the entire $110,000 or so of increase in value that his expert testified to.
Let me ask you, if the wife had bought a piece of super duper equipment for her dental practice and put it in in her dental practice, and it enhanced the value of the dental practice, are you claiming you're entitled to half of the increase derived from that new piece of dental equipment?
No, not under paragraph 4. That would seem to be, although I guess we're still torturing the words, an accumulation under the definition here. Our argument, and judges, I forgot, I would like to reserve 5 minutes for rebuttal, but
because you'd agree under paragraph 6 that new piece of equipment would be solely the wife's.
Yes.
So if it had the effect of increasing the value, you're saying that wouldn't count? I mean, he wouldn't have a claim against the increased value due from new equipment?
I would have a difficult time making that argument. I'm not sure how a new piece of equipment purchased in the business's name would be any different from a retained earning. You know, the money is still sitting in the bank account. A $10,000 piece of equipment or $10,000 of retained earnings in the bank account would still be an earning or an accumulation. But the enhancement in the value itself of the practice, it's more visible within the community. It has a larger client base. Words that do not properly form or facts that do not properly fall within any interpretation of the word accumulation should have been available to be argued before the court as part of what was not given away. I mean, you know, if you look at the Doig language and you talk about what the parties intended, I'm not sure that either Mr. or Mrs. Doig intended the result that the Doig case gave us. I'm fairly certain that the lawyer who drafted that prenuptial agreement was convinced that he was taking care of his client and making sure that anything that enhanced in value in the future was not going to be part of the marital estate. But we have the Doig language. No, wait, this just talks to passive appreciation. And we have the same situation here. In the absence of a very clear waiver, and we cite a number of cases to that position, that in the absence of a clear and unambiguous waiver of that, Mr. Brown had a right to at least present evidence. The case is Worley that Judge Vander cited a moment ago. It says, in order to find that a waiver of rights has occurred, the language used in the agreement must clearly and unambiguously express waiver, or the language must be such that an interpretation of the agreement as a whole can lead to no other conclusion but waiver. And we don't have that here. Certainly if we didn't have it in Doig, we don't have it here in the instant matter.
What do you think the overall intent of the agreement was?
In this case at bar? I don't know. I was not involved in the drafting of it. I was not involved in the trial of it. If you're asking my personal opinion, I'd be glad to express myself on that. And that is that any time parties enter into a marital settlement agreement, it is to fix their rights unambiguously in the event of a divorce, so that they are not before a trier of fact arguing over what the agreement means. And in this case, it's a 20-month marriage. So the amount is not great, but the other cases, and I think we have cited a couple, and I think the appellee has cited several, hold it. The whereas provisions that recite the basis under which the agreement is reached are not operative and therefore are not binding upon the parties. So whether or not they had an intention to do this or not, it's the specific language of the operative provisions that the court is constrained to follow.
But interpreting paragraph 4 of the word accumulations, we are to read it in the context of the entire agreement, correct?
You have cases that suggest that, Judge. I think you read it in context of paragraph 4. And
paragraph 4 only?
I think paragraph 4 primarily, and then if there is some reason that it's not understandable within paragraph 4, you begin to expand outward from there. But if you read, again, I'd ask you to read paragraph 4 very carefully, and they appear to use the term earnings and accumulations interchangeably with earnings and income. And we cite several cases that refer to Florida Statute 768.118 sub 5, the Wrongful Death Act, that gives a definition of net accumulations. And when words have a specific legal meaning, then that meaning should be applied and not a more general approach to the language. I have a citation for that proposition. I thought I had it marked. But in any event, that is the idea. That's actually, it comes from American jurisprudence second on contracts. In interpreting a contract where words have a definite legal meaning and effect are used, the parties thereto will be presumed to have intended such words or terms to have their proper legal meaning and effect. If they had used different words that didn't have a specific definition under Florida law, the argument...
Well, accumulation doesn't have a specific definition under Florida law in this context, right? And you had to go to a wrongful death statute to come up with a definition that's clearly not applicable in this case, right? So this is not a term of art in marital law.
That is true, Judge. It is not a term of art. And again, coming back to what I said earlier, if you try to draft an agreement that is so specific so that you're not arguing over the meaning and the intentions, that's the object of a well-drafted prenuptial agreement. That wasn't done here, and so again I come back to the Worley case that says unless rights are clearly and unambiguously waived, the waiver's ineffective. And I think that's what we have here, Judge.
You're down to about 3.5 minutes if you want to save it.
I have nothing else to say. I reserve it for rebuttal.
Good morning. My name is Elizabeth Harris, and I'm here on behalf of Dr. Brigance. And I think I'm going to begin with some of the comments that the panel has made so far. And I would agree that the Doig case is paragraph 2. And I think what Judge Ryman did was she saw paragraph 2 and said that is Doig. Now we have to look at this act of appreciation. And with regard to the issue of waiver, she finds that there was not an explicit waiver with regard to the former husband's interest in the act of appreciation of the dental practice. And that's the issue that goes before the court. And I think that the waiver is apparent in the first sentence with regard to Dr. Brigance herself, or rather that is hers. It's clear because it says and Judge Ryman finds personal service skills, efforts, and work to be marital labor.
Well, it seems to me the key for paragraph 4 is this term earnings and accumulations, and it appears that the language is not consistent throughout this paragraph unless accumulations and income are the same thing, since it starts out by saying all earnings and accumulations together with all income, and then the next paragraph says understands that except for this agreement the earnings and accumulations.
And that's the second sentence.
And then it talks about earnings and income. Then it talks about earnings and accumulation. So it seems to be all over the board. Are we talking about 2 concepts here? Are we talking about 3 concepts here?
Well, and I think I want to agree with your comment that it's not a term of art. Accumulations is not defined in the statutes. And as I understand your task as applying or interpreting what this means is you need to give this word its ordinary meaning. Now, I would suggest that the use of the words earnings and income would be, perhaps synonymous is not the correct way, but they would be inclusive of the same assets. Let me use that word just because I can't think of another one. As opposed to earnings and accumulations, which would suggest distinct items. And when you're applying that, and I went through this in my brief, is the plain and ordinary meaning of accumulations. It is not as suggested by the former husband that it is some type of savings on income. His brief indicates that the word accumulations means savings accruing from the excess of such earnings over his or her expenses. I would suggest to you that there's no foundation for that interpretation or that application.
Well, let's look at the last half of the paragraph, which says, starting about 8 lines down, after the and, by this agreement, the earnings and income during the marriage are made the separate property of the person to whom the earnings and accumulations are attributable. You've just interchanged, it appears you've interchanged the terms income and accumulations there, because otherwise, how do the earnings and income become the separate property of the person to whom the earnings and accumulations are attributable, unless income and accumulations are synonymous?
But alternatively, earnings and income then would be a redundant term. The earnings and income that are in the prior portion of that sentence would become redundant.
So do we have three terms that all mean the same thing? Earnings, income, and accumulation all means earnings?
I suspect that what we have here, and there's no basis for this before you, but I think what we have there is that income should have been the word accumulations. There's an error there in the, but that's, again...
Is it your position that the document is ambiguous?
No, because I think earnings and accumulations, it begins that way, all earnings and accumulations, and we're talking about this, what Judge Ryman finds to be the lack of waiver as to his claim, his portion. It clearly tells us all earnings and accumulations which result from her marital labor are her property. So based on that first sentence, we have the context in which this paragraph lies, earnings and accumulations. And accumulations, by plain definitions, are not earnings. They are something more. And particularly if you look at paragraph 2, this paragraph was intended to be that something more that paragraph 2 did not address. That Judge Evander noted from Judge Alderbrand's dissent, that's something more.
Actually concurring.
Oh, I'm sorry. Correct. Thank you. And that is the intent of this paragraph, to add the something more that was needed from the Doyd case. I don't really have anything else other to add. I think this is a case in which you need to apply the ordinary plain definition of the word accumulations, which is something distinct from certainly the definition that's been afforded by the appellant. We have no indication that that is what is intended to be here. If you don't have any other questions.
Thank you, Counsel.
Thank you.
Got about 3.5 minutes.
Since I don't intend to use, I just want to reiterate one point, and that is that we have to assume the attorney drafting this agreement was familiar with the Doig case. Judge Altenburn clearly gave us the language that is in common use now, even if acquired with marital income or by virtue of marital labor, active or passive. They're all in agreements when there's a clear intention to waive that active increase. And if it's not there, we cannot infer a waiver of an important right.
Is there any difference between earnings and income?
I don't think so.
So to the extent this paragraph refers to earnings and income, it's just redundant?
I think in this sense, can we construct an argument that says that earnings means earned income and income might mean passive income? I guess I could make that argument, but I think in the context of this paragraph, it's one and the same.
How does the business increase in value? It can increase by passively, which you agree is not at issue here. It can increase by new property being brought into the business, which you agree would be the separate property of the wife in this case. Or if the earnings increased, the income increased, that's a mark of a business, how much money is brought in to the business. I mean, what else is there to increase the business's value other than income, property bought and brought into the business, and passive?
Well, we're talking about valuation now. So from a valuation standpoint, if the business is doing more business, if it's making more money, then and a capitalization of earnings or capitalization of excess earnings or some other approach is used to the valuation of it, then that business has increased in value. That's not directly attributable to new capital assets being purchased, to retained earnings or cash.
It's attributable to increased income.
Correct.
Which is income generated by her personal skills.
But it's the income itself that was protected here. That's what was protected. The income, once it's received, the valuation of a professional practice like this is based upon some formula that says that the anticipated future value of this business to the investor. So if she sells the business based upon that type of formulation, the income is no longer hers, it's being earned by another professional, by another dentist, and that's what they are paying value for. It's the return on investment to the professional who's now going to take over the practice. It's not her income any longer, which is what was protected here. And that's the difference and the distinction that what was clearly was not waived by this agreement. If they wanted to waive it, they could have expressly said exactly what Judge Altenburn here said was, passive or active, it's all hers, he's got no claim, end of story, we wouldn't be standing here today.
Thank you, counsel.
Thank you.
Court will be in recess.